Hi, I'm Juliette Ferguson. I go by Jet with Sotheby's International Realty. And today I'd like to welcome Jed Peace. That really is his real name, and he has a birth certificate to prove it. Jed Peace Friedland, attorney at law.
Hi, thanks, Jet. Thanks
Yes.
for having me here.
And happy birthday. It happens to be his birthday, so you get to blow out your candle.
Thank you, that I will.
Woo! All right, that's our first birthday.
Can I
on
say what I
Jet
wish for?
TV. Yes, if you want.
So I wish that more people would appreciate the value of mediation and good communication skills, so why don't we talk about some of that?
That sounds perfect. Mediation is something that comes across every real estate contract when I'm working with my buyers and sellers. Especially with my sellers, I explain in advance when your offers start to come in, you're going to have to decide, you and the buyers are going to need to agree on if there is a problem, how you're going to handle it. So as the real estate contract states, the residential purchase agreement, it starts with mediation. And as you and I discussed prior, they can select a mediator and meet, and they might not even talk to each other, but they have to physically do this, yes, at first?
Well, let's talk about it.
Okay.
So I think you're referring to how things normally proceed under the car contract?
Yes.
Okay. So generally, and I'll defer to the specific language in the contract because it changes
Of
from time
course.
to time, but there is a provision in the car contract in which you have the opportunity to select a remedy should things go poorly.
Right.
And one of those remedies that you have an opportunity to select is something other than a lawsuit. And that would be either judicial arbitration, in which an arbitrator makes determinations, much like a lawsuit. They entertain briefs and they consider legal arguments, and they'll make a determination that will be binding upon the parties.
Okay.
The other option is a mediation option. And a mediation option is it's a looser arrangement. It's not a determination of who's right or who's wrong or how things will necessarily be resolved. It's more of an opportunity for people to gather either in one room or in a caucused environment, in a confidential setting, in a safe setting,
Like a facilitation.
where we can facilitate a conversation around their interests, around their concerns, in an attempt to get everything on the table, and then see if there isn't a way to be creative, using our own, and when I say our own, I mean the party's own, options and input to make a reasonable conclusion, a reasonable management or resolution of the conflict, as opposed to having a judge or an arbitrator
Right.
say, this is how it will be, like it or not.
And if they can resolve this in mediation, then it would save a lot of money as well.
It's very cost effective compared to the other options. It also is very time effective, and that's often critical when you're dealing with a real estate transaction, especially if you're holding on a closing or there's a lot of money at stake,
Sure.
or other contingencies.
Right. So if they start with mediation and that is not resolved, then they go to either, they can select in advance and agree on in advance on the contract, arbitration, or going to court.
Correct. Generally, the default is if you don't agree on a remedy like mediation or arbitration, say we're both parties to a contract and I say I want mediation and you say no, I don't. I want arbitration, I say no, I don't, and we can't agree. The default is litigation. Most folks are familiar with litigation at some level. It's not like what it looks like on television. It's far more costly, it's far less interesting, and it's far more time consuming.
And not always more expensive than arbitration, which is something I recently learned and was surprised.
That's correct, because really what you're doing is you're paying for the time involved to have advocates advocating for your interests, which would be lawyers, and a professional arbitrator who will charge a very large hourly rate. Generally with mediation, you may have the option of going in self-represented if you like, or using attorneys, but it tends to be more efficient and less costly. Now, there are a few wrinkles that I should probably put on this,
Sure.
And I think that this is probably referenced in the language in the car agreement.
Okay.
But there are some carve-outs for the mediation mandate with
Okay.
respect to the contract. And I'll defer to the language of the contract, but I want to just let your listeners or your watchers be aware of that. For example, judicial foreclosures,
Yes, that is,
bank foreclosures, other things that may involve third parties or may involve finances from people that are not signatories to the agreement,
right.
will take precedence. And just because you're electing mediation doesn't
Right.
mean that you're protected.
It specifically excludes those, so.
That's correct. It's only between the signatories on the document, that is the contract of sale, as between them as related to that transaction.
That makes sense.
Now, here's the other thing just to bear in mind. Generally, the whole notion here is that we're trying to motivate folks to work things out themselves.
Right.
We're trying not, both because it's the right thing to do and because
Sure.
we don't want to burden the court with a lot of extra caseload.
Right.
So the hammer that we use, when I say we, the legal system uses, is to say, look, normally in a court, if you sue under a purchase and sale agreement, you may be entitled to your attorney's fees back if you prevail as the prevailing party.
Right.
However, if you do not select mediation and then proceed by way of lawsuit, I'm sorry,
Arbitration.
let me back up. If you select mediation but then do not exercise the right for mediation and sue someone directly, you waive your attorney's fees. So once you've selected mediation, you must be consistent with acting in accordance therewith. You can't suddenly change your mind and say, well, I'm just going to sue them. Well, you can, but you'll give up a remedy that the law
Right.
entitles you to.
Right.
So at every juncture, the intent is to try and motivate people to come to the table, to express freely and completely their concerns in a confidential setting so that it can't be used in court against them later.
Sure.
And then if they can't work it out, then they can go forward and then they can file their lawsuit. And if they're prevailing party, they can get their attorney's fees at that time.
And when we were talking earlier, you really felt passionate about one thing you could do to prevent mediation?
Well, to prevent even litigation and arbitration and mediation, in my view, really where I come at this from, even though I'm an attorney and I'm a mediator, I come at this from communication perspective.
Right.
Because what I see time and time again, whether I'm acting as a mediator or whether I'm acting as counsel for someone as in an advocate position, is that we could have solved this earlier.
Right.
Even where, and I want to say that, even where there are bad actors, even where there are people that are acting with malintent. Now, I need to be clear, mediation is not for everyone and everything. There are times that matters need to be litigated, which
Sure.
is why it's critically important for your buyers and sellers to make an intelligent decision
Absolutely.
before they check
We
that
discussed
box.
that so clearly on it's so important. And I do have buyers and sellers ask me what my preference is, and I can't give that advice because my preference doesn't matter and it might not relate to to them.
That's right. You can't be giving legal advice. And while I'll
Exactly.
say, I'm happy to say here on camera that my preference is mediation. And I'm also happy to say that despite that, I don't want to give you advice about that because in your particular context, based upon the time, based upon the people involved, based upon the specifics of the transaction, you may determine that no, mediation is really not a good option for me.
Sure.
If things go awry here, I want to be able to sue and sue quickly, or I want to be able to arbitrate. Those are all within your rights to be able
Gotcha.
to select as a consumer. Now, I'll just mention one other thing,
Yeah.
which is that mediation surfaces in so many areas related to real estate.
Oh, yes,
You know,
I'm
from
sure.
land
yeah.
use and landlord-tenant and just
Eviction
so many.
could avoid eviction court.
And we'll even have in-court mediators at the time of eviction court, and we could talk about the pluses and minuses there. And then you've got the commercial side and you've got
Sure.
the residential side. There's just so many
So you
things
could come
to
here and
talk
do
about.
10 shows?
Probably 50 shows. But I need 50 more cupcakes.
That we could do. We're running out of time, but
Okay.
is it okay if I give your phone number?
Sure, absolutely.
Okay, this is Jed Peace Friedland. He is an attorney and he is a mediator, arbitrator also.
I do some arbitration. I instruct
attorney.
mediation as well. Mediation
Oh,
is the
right.
way to go.
You teach at the college. Okay, we're ending, so let me give you your phone number. Jed's phone number is 831-809-2577. Jed Peace Friedland.
Thanks
Thank
for
you
having
so
me.
much for coming and happy
Thank
birthday.
you. Thank you again.